Right to information is a fundamental human right under Article 21(1)(f) of the 1992 Constitution of the Republic of Ghana. Well, to give effect to this constitutional provision, the Right to Information Act 2019, that's Act 989, was passed by Parliament and assented to by the President on the 21st of May 2019. Well, Act 989 affords everyone the opportunity to access information from public institutions. The Act established the Right to Information Commission with the object to promote, monitor, protect, and enforce the right to information granted to a person under the Constitution of Ghana. Clearly, the law is there all right after decades of struggle, but it appears it is being selectively applied. Well, the key question is the right to information really a right or a privilege? The Executive Secretary of the Right to Information Commission, Yaw Sapong, is my guest tonight on The Probe. You have any experiences to share with me, feel free to do so via our WhatsApp platforms at 055-1111-997 or leave them on our social media platforms. We are live on Joy News, Joy 99.7 FM, my Joy Online. We're on DSTV channel 421, Go TV is 144. I am Emefa Apawu. Welcome to The Probe. We'll get talking right after this. Welcome back. This is The Probe, and tonight we are asking if right to information is really a right or a privilege. And the Executive Secretary of the RTA Commission is my guest tonight, Yaw Sapong. Good evening and welcome to The Probe. Good to have you in the studio.
Thank you.
How's the RTI doing? The Commission?
We are doing our best to implement the law.
Are we implementing it such that it is actually a right and not a privilege?
It's indeed a right, and rights do come with privileges. So to an extent, we would have the challenges that the law itself has set up. And then when it comes to interpretation, some people may misapprehend what the law is actually about. So it's a living document. We are seeking to grow it throughout the years.
I'll get to that key question because I see a lot of questions that I've received from our audience on this particular issue and their experiences. But the Commission, would you say we are fully set up now?
Yes, we are.
Staff strength, logistics?
Yes, so the Commission started with just a 7-member board. Now I can say we have a staff strength of about 127. So yes.
127?
127.
Then how come decision making is so slow?
If you'd appreciate, the wheels of justice grind slowly.
Even at the Commission?
But it is such that you would have the best of results when it is taken. So we have to be patient. That is why the law itself doesn't put any timelines on the Commission to make decisions.
But it's just about getting information. So how is it that wheels of justice grind slowly at that point also?
Okay, so the Commission is not in the business of giving out information. What the Commission does is it regulates the processes for giving out information. So we do not receive applications for information. When you have challenges with your public institutions, we try to help you address the challenges that come with it. Yeah, so we are at the resolution end of the challenges in the application process.
So let's talk about a typical resolution process, because I have a number of cases that I've received, at least once we put out the artwork, that tells us about the decision making that you ought to have taken at your level and how long it's taking. For instance, there's an application for information on presidential travels.
Good.
And since February, we are told that there's no decision on that. How come? Is it because it's the presidency?
So it's not because it's the presidency. Now, you'd recall that when you have such problems coming before you as a commission, the law indicates that you must investigate, all right? So you want to appreciate all the challenges that come with it. This case has, for instance, been to Parliament. There have been some requests at the parliamentary level. If you want to come up with a good decision, you must also appreciate what happened in Parliament to be able to come up with a very good decision. I do not want to go into the content or the substance of that case, for instance, because what I may say may prejudice the outcome eventually of that decision. So I think that we just have to be patient to get everything going.
How patient again? Because since February, that's why I'm asking.
There are cases that are still
September
before us
now.
since 2021, and we are still working on them. sometimes you want to take the time to listen to both sides of a matter. And like I said, it is not for nothing that the law did not put timelines to how long you take to resolve a problem before you. So we need to be patient. When the decision is taken, we want to make sure it's airtight and it helps in the adjudication of the RTI matters.
Okay.
It helps in setting a pace for us to appreciate what this right to information law is all about. Yes.
Well, there are those who are of the view that the law is in existence, but there's a selective application of this particular law.
Yeah, I doubt anybody can say that, because if you go online, for instance, decisions we have made in 2021, we have published for everyone to appreciate, everyone to access and read. Now, when you pick a decision we have made, all right, at the RTI Commission, and you criticize it to that extent, then I can engage on that level. But when anybody just sits anywhere and just says it's being applied selectively, I think that
because it appears that it depends on
to the process.
It depends on who is involved.
It
if it is a so-called big man or a big institution, then you don't get to get that information.
So the law is what is in the Right to Information Act. It doesn't care who I am to implement it. If the law says ABC, I can only apply ABC. My sentiments do not matter. Who you are do not matter in the application of this law. So I believe that those who are saying so should actually take part in the process of applying for information, have challenges, and come to the commission. And then they are able to tell that when I had this case, this is how the law was applied, and it was selective in its nature. But when you haven't had the experience and you just come out to make such accusations, then I think you're...
But I tell you, I've given you a typical example.
You're only talking about time, but that doesn't mean it is not...
I've given you the case of the presidential travels,
for instance,
and how long it's taking.
Yeah,
you've talked about the fact that it doesn't have timelines.
Yes,
but
there are cases even in the courts that take over 10 years to arrive at a decision. So like I said, you don't put pressure on the decision-making process. You rather hope that when the decision is made, it is airtight, and that the challenges will be limited. That's what we should be looking at, not a matter of time.
Okay.
You understand my point? Yeah. So we should focus on the decision.
On the decision itself. But if it doesn't matter when it comes, that's what you're saying.
It should be a good decision that will help guide the adjudication process in Ghana. I think that's what's most important.
So there's a case also with the Toby Afede situation. We'll get into the questions that the audience have asked, because I see there are a lot of questions to you on this. But there was a case that we all heard about, the Toby Afede situation. Asked for information from the Council of State, was referred to go to Metro TV. I'm told that issue has come to your commission, correct?
I think it is before us, and for the purposes of education, I'll speak to it. But to the extent that I'll go into the substance, I'll refrain. Because it's a decision, it's a case under investigation, like every other case I'm talking about. But I think that for the purposes of education, I will speak to the law. Section 21 of the Right to Information, if you permit me to read, speaks about referring certain applications that come to an organization where the information is in an official publication. Then the public institution has a duty to refer the applicant to that official publication. It does not say refer the applicant to an individual who has also applied for that information, or an institution that has also applied for that information, if you appreciate. So I think that there must have been some misapprehension on the part of the Council of State, who was of the view that once we have published it to Metro TV, then we can direct you to go to Metro TV. But that will lead to an absurdity if we want to apply the law in that regard. Now, what it will mean is that as individual applicants, we can have other applicants referred to us. That's not what the law sought to achieve. What the law seeks to do is to actually help in making sure people get information. So if the information is already in an official publication, so what is an official publication? Have you already put it on a website? Have you already put it in a report where you can direct me to go to the report? then you can be coming under Section 21. But in this case, I think that what was an official publication was misrepresented to mean Metro TV.
Okay.
So you can tell where the decision will actually go to. But it's because I want to draw the attention of public institutions to appreciate what the law says, not to interpret it to an absurdity.
So in effect, the Council of State shouldn't have referred Toby Afeda's office to Metro TV for that.
Metro TV is just like an applicant for information. It's like you, Emefa, apply for information. You get it. Then another gentleman comes to apply for that same information. And then they refer that gentleman to you, Emefa. I mean, it's not your job to be giving out information. But what we encourage public institutions to be doing is that disclosure of information to one person should be disclosure to all. So if Emefa applies for information and I give it out to Emefa, I should be able to publish it such that it is disclosure to the whole world. Then when another person comes for that same information, I can refer you to maybe a publication on our website that we already put out that information. So you don't need to go through this process. Just go to our website, you get it. If we proactively put out information, we'll reduce the burden of persons applying at our various public institutions for information.
Okay.
And that's what we seek to achieve in the end.
But this is a clear case then. How come a decision has quickly not been taken? You've quoted the law. It looks like it's a straightforward
so one
situation.
person complains in a case. You don't just jump because one person has complained. You also hear the other side. It's a principle of natural justice. So if you would also appreciate it, when you are adjudicating matters, you must always hear the other side. You give them time to respond. And then when you listen to their reasons, you can say, okay, I've heard both sides. Because if I take a decision based on one side of a matter, then what it means is that anytime that case or that decision we have come to shows up in the courtroom, it will be set aside because it breaches the principles of natural justice.
Well, this is The Probe, and we're live on Joy 99.7 FM, also on the Joy News channel, myjoyonline.com. I'll get into the first batch of questions at this point, and the Executive Secretary of the RTA Commission, Mr. Yao Sapon-Boateng, is my guest in the studio. So, yeah, if you're ready, let's get into the first batch of questions. My director is also Yao, so... So we'll get into the first batch of questions for tonight. And Akosia says, does the Commission have a way of determining how public institutions comply with their mandate under the Act? That's Akosia. That's the first question. And we have this one from Ifia, says, public institutions are obliged to publish an information manual. What information must be contained in the manual of public institutions? We have another one. Solomon says, what are the measures put in place to ensure that all public institutions have an information unit? That's Solomon. And then I'll take the first batch and then I'll come to you. And Lisa says, how can a person use the law to ask for information from a public institution? That's Lisa's question. We have one from CC says, how long should it take for a person who applies for information to receive the information from the public institution? The final one. Oh, that's it for this batch. Okay, Coco says, what happens when an applicant asking for information is dissatisfied with a response from a public institution? Okay, so that's the first batch of questions. Maybe we'll start from Cece's question, the very last one. Or should we start from the top? Okay, we'll start from the top with Ifya. It says public institutions are obliged to publish an information manual. What information must be contained in the manual of public information? That's the first one. This particular one.
The manual.
Okay, yeah.
Okay. So
that's
an
Ifya's
information
question.
manual is actually a guide to the kind of information that you would find in a public institution. It doesn't have to contain the information held by that public institution. It has to be a list of the information you are likely to find in that public institution. So yes, the law makes it a requirement that every public institution must have an information manual. In January this year, the Commission issued guidelines for the preparation of information manuals. And most of our public institutions have complied in publishing their own manuals. What this is to do is to guide an individual applicant who walks into an organization to be able to tell what to find in that organization. And on that note, you would not have to waste time to go to an institution that does not have information you are likely to find. So it's a guide, all right?
But we are supposed to be having desks. Apart from this manual, most of these public institutions, we are told, there's no RTI desk.
It's a new law. The implementation will be slow, but eventually we will get there. So I'm not quick to rubbish the process. What we should be doing is to court the public institutions to get to appreciate what this law is about and help them to establish these information units and then put in place an information officer. That's what we've been doing. So far this year, we've been going to public institutions on a daily basis to ensure that we sensitize them to appreciate what this law is about. It's a matter of education. We cannot assume that once the law is passed, everybody knows what's in the law. So we should use platforms like these to educate the public, to appreciate what is required of public institutions and how the individual can also use that right under the law.
Okay.
Yeah.
Well, and staying on that, that's Ifia's question. I'll get to, I see that the CC's question is on the screen, but we are on Ifia's question. But there are also concerns about those who have applied. And even for the search, they are being charged, even though they are supposed to be charged for reproduction.
Okay.
What happens to such institutions?
So when you say a search, there are differences between some public institutions that have fees meant for searches.
Okay.
For instance, if you take the Lands Commission and you have a landed property you want to conduct a search on, if you go to the Fees and Charges Act, there is a fee that is specified to be paid to the Lands Commission for that purpose. You cannot run under Right to Information law just because you want to avoid the fees.
How about it's not the Lands Commission, for instance?
So you go to, let me use the Environmental Protection Agency. They also have searches that they conduct. And there are fees that are assigned for that purpose. You go to GMPC, you want to request for some seismic data. It's economic data. The law doesn't waive the fees that you have to pay under such circumstances. So there are some economic information that you certainly have to pay for. But if you make applications under the Right to Information law, and there's no law specifying fees separately from what the Right to Information indicates, then what the law says is that you are to be charged for the cost of reproducing that information.
Exactly.
All right. So if I want information in the form of photocopy, obviously an organization will spend money to buy paper and to buy ink for print and to buy toner.
Why should we be paying for that?
You should be paying for it because we can also have a circumstance where the woman who deals in granite, all right, shows up every morning, requests for 200 sheets of paper because it's her right to information. And then she ends up only using the documents to sell her granites. So if you need the information that much, then paying for the cost of reproduction shouldn't be a big deal.
In any
event, the law anticipates that it's only a token.
Okay.
All right? Because how much can it cost me to photocopy a document? You can't be unreasonable about that. Yeah. But the initial stages of people charging fees beyond what they ought to have charged is all part of the teething problems that we'll have in terms of the implementation of the law. And I think that the courts have helped to settle these matters.
Okay.
Yes.
And there were some sanctions, at least from the Commission. I know about the fire service. I know about the police service. There are a few sanctions, but it appears that nothing has happened.
So what it is that the law gives the Commission power to levy penalties on non-compliant institutions and institutions that ought to have done A or ought to have complied with a certain directive of the Commission which has failed to comply. Now, we are in the process of getting our legislative instrument, which will even make us even more stronger, where when penalties are levied against an institution, we are able to take the monies from your account without you taking us through the full haul in a litigation process. So, like I said, we are in the teething stages of implementation, but we will get there as a nation.
I think that takes us to Akosia's question about does the Commission have a way of determining how public institutions comply with their mandate? You talk about
it's not necessarily the Commission. It is actually what the law lays down for every public institution to put in place. The Commission is only a making of the law. and we can only do what the law requires us to do. Yeah. So every public institution is under obligation under the law to generate, process, maintain, and preserve information which is accurate and authentic. That is an obligation that the law places on every public institution. Yeah. You should make sure your information, you have kept it in a way that makes it easy for people to access, and that it is authentic and genuine, so that you don't misinform the public. All right? Now, information by itself belongs to the people. Information is generated in the public discourse, all right, by taxes paid by individuals. Okay? So that is why we don't necessarily pay for information, but we pay for the reproduction of that information, because we paid for it anyway. And therefore, anyone who keeps information is only a custodian of information. All right? When the law says you must give out this information, you ought to give out that information. You asked whether it was a privilege or a right. Yes, it's a right, but it is not every information that we can give out. So there are exceptions to information that must go out and which ones must stay in the organization.
Okay, so with a bit about the search and the reproduction, there's a clarification at least that I got from, you talked about the EPA and Lands Commission.
Yes.
But in this particular case, was the EPA, they were asking for information about some permits that was given to a telco to mount a mast. This particular information for them is not an economic data. How then do they pay for the search for this particular information?
So like I said, what I actually encourage applicants to do is that when you have a challenge, don't throw your hands in the air and just give up. Right.
But if the system is that slow, you talked about it grinding slowly.
I've never said that the system is slow. I'm saying that don't push for speed only to make mistakes.
Okay.
That's all I've said. Yes. So I'm saying when you have applied for information and you did not get the information, don't just throw your hands in despair. There's a commission, there's a lay-down process for getting redress. So why don't you activate that process? So you went to a place to get something you were not giving, and then all you say is, you complain. You understand my point? You have a right under the law to use the services of the Right to Information Commission, where you do not pay a dime for the services that the state is already funding. So why don't you activate that right?
Okay. Yeah. Well, let's go to Solomon's question so that we can cover a number of questions. And it says, what are the measures put in place to ensure that all public institutions have an information unit? So we're talking about the fact that most of them don't have desks, but what exactly are we doing about it?
So the law places an obligation on the Right to Information Commission to educate and sustain awareness of the Right to Information law within the country. I indicated that we are educating public institutions to continue to appreciate what the law requires of them.
Are they respecting the law?
They don't have a choice. They have to respect the law. Where they have failed to respect the law, like you said, we have levied the penalties that we ought to have levied. You understand?
Are they paying? Are they abiding by it, at least? Because we are told that some of them are simply ignoring the sanctions.
Yeah, you can ignore it, but it continues to accrue interest.
Okay.
So at the point where we are able to recover the money, you may lose all the money that you have to run your organization, because it doesn't just sit there. It keeps accruing interest from day to day. So it is in the interest of every public institution that has had penalties levied against them to pay upfront. Because if you allow it to rest, by the time we recover, you may be paying 20 times what you should have paid. Okay. You understand? We were talking about
the information
units. Yeah, it's a requirement under the law that every organization must have an information unit. This information unit is very different from a public relations office. Okay. Because what the information officer is required to do under the Right to Information law is entirely different from what a PR office does. He's supposed to receive requests for information requests, process them, and make the information available to the applicant. Where the information is exempt under the law, he must indicate so for the applicant to know whether or not to appeal the decision of the information officer or otherwise. And there are sanctions placed under this law for any public officer dealing with information. You ought to act within the remits of the law. Otherwise, you incur some liabilities and it becomes personal. So it is required that every public institution puts in place this information office so that there is a designated officer or an information officer who actually deals with requests for information. Then you reduce the risk of people giving out information that ought not to go out. All right?
Have we had cases like that?
I'm sure we may have had cases like that. We are just slow to punish because, like I said, we are at the teething stages of the implementation of the law. So we should expect that we will make some mistakes will come up. Yeah, but we are almost 2 years into implementation. So we are slow, but very soon we'll be cracking the whip.
Okay. So Lisa is asking the basic question about how a person can use the law to ask for information from a public institution.
Okay. So as an applicant for information, you walk into any public institution, they must have an information manual. In the absence of an information manual, or if you have the information manual, you can tell whether this information I'm looking for can be found in, say, Joy FM.
Okay.
All right? When you check and it can be found there, you make your request for the information. Now, the information officer has up to 14 days to process and indicate to you whether or not the information you are requesting for is available and can be given to you within the time period. Now, if for any reason you require the information urgently, the law says you must indicate the reason for the urgency. Let me state that under the law, no public institution should force you to indicate why you need the information. It is not allowed under the law, or it's not permissible for any public institution to want to know why you need the information. It's your right. And whatever, even if you want to sleep with the information, it's your business. So it is not a requirement under the law that you must tell us what you are using the information for before we give you that information. So it
doesn't matter who you are.
It doesn't matter.
You can just walk in.
In fact, you don't even have to be a Ghanaian. You could be a foreigner. This law is not just meant for Ghanaians. Once you find yourself within the jurisdiction, you must do so. So you go into a public agency, you identify yourself, he takes your application, he processes it within the 14 days. If there's an urgency, the only reasons you are giving is the reason for the urgency. All right? And then your information will be processed.
And the urgency would, in some cases, lead to why you need the information.
But that's because you want it urgently. So sometimes it may require you to open up a little so that the information officer can work on it for 48 hours. That's what the law permits. That in that case, it waives the 14-day rule, and then he must work within 48 hours to make sure you have the information. So it's in your own interest, but you have a right not to disclose it. No one can compel you. You understand?
Okay.
Now, when he has given you the information, or when he decides not to give you the information because it is exempt under the law says he must indicate under which provision of the law, all right, that he is not able to give you that information. So that if you are dissatisfied, then you can appeal. So you cannot just say, I will not give you this information, but you must tell the provisions under which this information should not be given out. Then the applicant can decide whether to take it on or to let it lie. So he is duty-bound to either appeal to the head of agency or the head of the institution to say, I was at your information officer's place to request for this information. He failed to give me that information. Or 14 days passed and I still didn't get a response. The law says when 14 days has passed and you didn't get the response, you must deem it as a refusal. Okay. And therefore, you can still activate the review process. If there are two things that the head of agency could do, he may agree with the applicant, with the information officer, and affirm his decision, or he may set aside his decision and allow you to get the information. If he affirms the decision of the information officer and you are still dissatisfied, then the Right to Information Commission is open for you to come and seek redress. Now, the Right to Information Commission does not take any fee for whatever services you are looking for at our level. But that aside, when we are done and you are also not satisfied with our decision, you can still appeal to the court for a review of our decision. Yeah, but the law has a strict requirement that you cannot go to court if you have not been to the Right to Information Commission. Yes.
Okay. Well, I think it answers CC's question about how long it takes. You've talked about 14 days,
14
right?
days,
As a standard.
yes.
But if you want it urgently, then
48 hours.
then you pay extra.
No, you don't
have
pay extra.
to. Okay.
You only pay for the reproduction
Okay.
of information.
Okay.
Time is not calculated in billing you.
Okay.
Yeah, and the fees are such that, in fact, the 2022 Fees and Charges Act has a provision for right to information applications. So I believe it will settle all these matters. And you realize that it's the 1 CD, 2 CD that you will see. So if you require information and you go and indicate that you want information from 1950 to 1999, then you should expect that the documents you are talking about will be huge. And therefore, even if it is 2 CD, 1 CD, the cumulative effect will make it quite expensive. Okay. So when you are also applying for information, apply for what you really need. Don't just apply because you have a right. I'm
sure you've been interested in finding out the kind of information that the various public institutions have been asked for. I don't know if you've been interested in that in terms of the kinds of information that people have been asking for since we started implementing the law.
Okay. So we have a reporting line at the Commission where every public institution is required to file an annual report with the Right to Information Commission. It gives you a certain breakdown of information that should come to us. By gauging the information we get, we are able to tell which industry gets a lot of requests from. Okay. So if you go online, rtic.gov.gh, we have filed our 2020 annual report, we have filed our 2021 annual report, and we have published it online for everyone to be able to appreciate what you can get from us and the kind of work we do at the Right to Information Commission. We have also published our decisions so that if you're able to read and appreciate the decisions we have arrived at, you can even predict that if I take this situation to the Right to Information Commission, looking at their previous decisions, this is the angle it is likely to go. So for purposes of educating ourselves and for review of our work, we have these reports that we have filed.
Okay. Do we have more journalists, for instance, asking for information in terms of the rankings? Do you have CSOs, more journalists? What exactly does it look like?
I think it's a balance. It's a balance between the applicants. CSOs are asking, journalists are seeking information, citizens are generally also seeking information. Students are doing likewise. So it's a balance. And one thing I like to say is that this law is not meant for journalists. It's not a media law. It's a law.
Did anybody say it's a media law?
No, there's a wrong impression out there that is for journalists alone. So most of our citizens are leaving journalists to do all the hard work. But we can all get involved in the process of requesting for information. The whole purpose of putting in place this law, if you read the early sections of the Act, it says it's an act to provide for the implementation of the constitutional right to information held by a public institution, subject to the exemptions that are necessary and consistent with the protection of the public interest in a democratic society, to foster a culture of transparency and accountability in public affairs, and to provide for related matters. So the whole idea is to make our public exercise quite transparent. That people, when I sit behind my desk to take a decision or to do some work for and on behalf of the people, I should expect that the people will come and subject me to questions on how I did my work. So every time you're doing your work, you ask yourself, if I'm questioned, am I going to be able to give out the information freely? If you are not sure about it, then it means you must not be doing something right. So that's how we should all be approaching our work going forward.
Okay. Well, I'll be getting into the next part, but there are concerns about letters or requests being rejected in some public institutions, even at the presidency. I've had some of my colleagues write to the presidency for some information, and their letters are rejected. They've come to the commission, and it appears that nothing much is happening.
No, I doubt. There's no way anybody has come to the commission that nothing is happening. Because on a daily basis, we receive requests from all manner of applicants, all manner of institutions, and we are working on it day by day. So if anybody makes that statement, I would vehemently oppose that.
Can the commission bring the presidency to order?
This law is no respecter of any institution. every institution is covered under this law. It is the kind of information that may be involved, that may be exempted. But you cannot say, I'm the office of the president and therefore we are not covered by the right to information law. Or I'm national security and we are not covered. Or we are the Ministry of Defense and we are not covered. But the law says, at a point where some information is being requested, it is that particular information that we may weigh to see whether or not we ought to give that information.
I think that is left to your discretion. Not. For instance, if that is left to your discretion, that you have to weigh the information that I'm asking for. I understand. I'm only asking, or the question they are asking is presidential travels. They want to know. And if that is left to the presidency, then we'll never get that information, would we?
But you see, this same law that gives us the right to information has also exempted some level of information, like I said. It is not because of the office of the president. It says the level of information. For instance, let me take you to information relating to the president or vice president. Imagine that a memo has been prepared for use by the president or the vice president. And while it is about to be utilized, an individual applies for that information. The law says that because that information has not yet been utilized, we cannot give out that information. We must exclude that information under the law. So you see how it works. But if it has been utilized, then the law says it becomes public record, and therefore giving it out shouldn't be a challenge. So at every point, it is the information involved and the effect it is likely to have on people. The law exempts communication between a lawyer and a client from disclosure, a doctor and a patient from disclosure. So for that,
but that's not the kind of information that is.
No, I'm just saying. So there are about between Section 5 and Section 17 of the law.
Exempts.
The law exempts a certain category of information. All right. Personal information is exempt. So if I come to Joy FM and I want information concerning Emefa, Joy FM may have come about that information because Emefa was their employee or is their employee, but they would require your permission to give out your personal information. So it is not just every information we can give out. I applied and I haven't had it. Sometimes there are consultations going on between the public institution and the individual involved to be able to determine whether or not they have their permission to give out that information. So a lot goes on in the background as well.
Okay. So if the letters are rejected, for instance, from these public institutions, they ought to exhaust
I think
all the processes?
The challenge in that arrangement is how people address their request for information. Some apply to the minister. Some apply to information officer. And the head of institution is not aware of this law.
Okay.
That there must be an information officer. So you go and then they negotiate you out of how you even address the letter and say to you, by the way you address the letter, we are not able to respond. So go and address it to the head of institution before we can respond. So all this kind of misapprehension or misappreciation of what the law is about is part of the reasons why we are having these challenges. But like I said, if you have any of such challenges, don't give up. That's why the Right to Information Commission is available.
Okay.
We'll look at it, we'll prompt the agency, we'll engage them, we help. Sometimes it's not even about whether we want to give out the information or not. There are some public institutions who are of the view that by their nature, they are not the kind of public institution anticipated by this law. So for instance, government may have 50% stake in an organization, and then the public has some stake. So they see themselves as not as a commercial venture.
Okay.
And therefore, why should you ask for information from us? But let me take this opportunity to read the definition of a public institution under this law. The law says, under Section 84, interpretations, it says, a public institution includes a private institution or a private organization that receives public resources or provides a public function.
Okay.
A very inclusive definition, which if we are not careful, by extension, multimedia group will become a public institution.
It's not part. Well, so we'll take
and the question then, you see the way you are quick to say so. The question then is, do you offer a public service? Yes, that's what the law says.
Service.
So if you're offering a public service, then you must be subjected to the same standards that everybody...
But not public resources.
It didn't say end public resource. It says or public resource. So once you are caught up in one web, you have to open up your activities.
Okay.
Right.
Okay, so I'll take a quick break, but since we are talking about public institutions and all that, Sarah is asking if it doesn't have an information officer, it's not there, but who do you address the letter to, and can any other person at the institution provide you with the information?
So if there's no information officer, I'd recommend you address it to the head of the institution.
The head of the institution.
Yes. Because the law also recognizes that when the head of the institution decides to deal with the application, he will be treated as the information officer.
Okay, let's take a quick break here on The Probe. We are talking about right to information, whether it's actually a right or a privilege. We've been taking some of your questions. Just keep them coming in. This is The Probe. We'll be right back. Welcome back. This is The Probe here on the Joy News channel, also on Joy 99.7 FM. We're on myjoyonline.com. We're talking about the right to information, and I see the interest everywhere. Keep your questions coming in. Mr. Yao Sapong Boating is my guest. He's the Executive Secretary to the RTI Commission, taking all your questions tonight. So this is a good time for you to send them in. Yeah, let's get into the next batch of questions at this point, then we can get talking. And this one from Lauren says, is it every information that people are entitled to under the law? I think we've been talking about that, Lawrence. And then Letty says, how can RTIC collaborate with state institutions to sustain awareness within the country? And Lady says, aside the regional sensitizations, how many public institutions has the Commission sensitized? And Hashmin says, can students ask for copies or inspection of their answer script if they are unhappy with the marks awarded to them during public examinations such as BEC, WASI, or exams taken at the tertiary level? Well, these are questions that have come in. So the very last one, very interesting one, BEC, WASI, exams taking at the tertiary level, he says. So this is it. He's asking if you're able to ask for information on that for remarking. Because you know when WASI and all that, you never see your scripts.
Okay.
So
we have had similar situations before us. Now, these are more or less professional level examinations. I believe at the institution level, if you write an exam, end of term exam, you are always able to access your script and you are able to go through for correction's sake. Now, at the BEC level, WASI level examination, sometimes you write in Achimota School, your papers are marked in the Upper East region. Yeah. Your raw score is recorded and you are able to access your raw score. But the paper, if we are not careful and we push these limits, it will lead us to some level of absurdity where over 400,000 students write and everyone is demanding their marked script. It gets to a point you must have a cutoff. Okay. That is the very reason why, even under our laws, when we have limitations, okay, if, for instance, an individual owes me money, after 6 years, if he never claims that money, you cannot litigate that matter again. So we must have some limitations to these kind of rights. Otherwise, we'll be creating more problems for our institutions than we can imagine. Most Ghanaians write international exams, such as the ACCA, the ACI, and the others. You never get your marked script, but you get your raw score and you get your grade. If you disagree, there's a process for asking for a remark. In the process of remarking, your paper will change examiners, will exchange hands with examiners. Yeah. They will remark it and give you your scores. But even at the university level, how many of us saw our marked scripts at the university level? We only saw our grades. And if you were dissatisfied, there was a process for you to go for a remark, but you will never see your
But for WASI and BEC, it may be difficult, but at the tertiary level, that's the same institution. It's not marked elsewhere.
So you see,
can't I ask for such information?
In as much as to what end do you want your marked script?
I want to be sure that
you want to be sure. But if you doubt your performance, there's also that opportunity for you to have the paper remarked. Okay. So it's not as if they take the right away from you, but they give you an opportunity for remarking. So why not?
Okay. So under such circumstance, BEC, WASI, those exams, those external exams,
I doubt it will be possible to give out that kind of information.
Okay, so
but if it comes to worse, let the courts decide.
Okay.
Yes.
Well, I'm sure that we'll have to test the law on that. But Lady has a question, and aside the regional sensitization, we're talking about
aside the regional sensitization exercises we've been doing since we came into office, we are also engaged in public institutional sensitization. This year, within the Greater Accra region, most of the agencies have their head offices in Accra. We've engaged close to about 30 institutions on a weekly basis to help each organization appreciate what this law is about. So we are in the process of engaging much of these institutions.
Okay, so it's talking about collaboration
also. For the month of September, we seized these exercises because we are having the Right to Information Week 2022. And it is such that it coincides with the International Day for the Universal Access to Information, which is recognized by the United Nations on the 28th of September every year. Okay. So this month, we ceased all sensitization exercises, and we are focusing on the week activities that will lead us to the celebration of that day.
So what's the lineup for the week? Maybe briefly we can touch
on that. We had a health walk and screening publicity exercise yesterday that went on very well. Okay. We are having a What Do You Know quiz within the GTV studios on Sunday. Okay. And then we would have a stakeholder engagement on the implementation of the Right to Information law, which will be a conversation between all CSOs, media houses, and the public alike on the gains we've made, the challenges, what we can do better. We'll have such a forum at the Right to Information Commission on the 26th of September. And then on the 28th of September, we'll have a public forum at the Alisa Hotel where we will recognize the day and come up with activities on the theme. It has to do with artificial intelligence, e-governance, and access to information. Okay. We are looking at how we can get much of our public institutions to appreciate the essence of putting the information they hold in a digitized form, make it easier for people to access that information.
Okay. So then Letty was asking about the collaboration with these state institutions to sustain awareness within the country.
We have, for instance, engaged with the NCCE, which also has a very wide network for sensitizing the public on state laws. And we had some engagement with their regional and district directors to appreciate what this Right to Information law is all about. That arrangement, I believe, will go a long way to reach the districts. That will help them to continue the sensitization that we have begun at the national level.
In your opinion, do you think that the law has generally improved access to information in the country?
I think we already had access to information as a right
under
the 1992 Constitution. What we did not have was the processes for activating that right. That is what this law has come to make clear. So that if I go into a public institution, he cannot tell me by what means am I coming for that information. Now it is clear how I can request for the information and what duty they are under to make sure I get that information. So this law has streamlined the processes, and we must take advantage of the law.
And there's a prosecutorial fiat also.
Sure. So the Attorney General, we engaged with the Attorney General's department. He was magnanimous enough to give us that prosecutorial fiat for us to prosecute our own offenses, because already the Attorney General is overwhelmed with a lot of cases. So if the agency wants to help in the process, why not? So it has trained many of our staff, all right, to become prosecutors. And we hope that very soon the process will be sealed. And then when people infringe on the Right to Information law, we can initiate prosecution from the Right to Information Commission. The training ended in August. So now we have the men to actually initiate the process of prosecution.
With that staff strength of 127?
Yes.
And is that enough for you to be able to undertake all this?
It is enough.
I'm told you don't have a legal department.
We do have a legal department registered under the General Legal Council's arrangement.
Okay.
Yes.
So, but we don't know the timelines as to when you're actually going to start
The
prosecuting.
prosecutions. So your legal department is not even the department for prosecutions.
Okay.
There are people beyond legal department who are trained for prosecutions. When police officers prosecute offenses, they are not lawyers. They don't even have any idea what the law is about, but they've been trained as prosecutors. Yes, so we have staff who are not necessarily lawyers who have been trained as prosecutors.
True that your budgetary allocations woefully inadequate.
Very inadequate, but like every public institution, we'll do our best in the limited circumstance. And we use every platform we get to call on well-meaning organizations like multimedia to assist the work of the commission if we indeed want to see the right to information law implemented to its fullest. I think it's one of the agencies that you can support as an agency or a business if you want to support some corporate social, if you want to go into corporate social responsibility or take up some corporate social responsibility. The Right to Information Commission is one of the agencies you can look at.
Okay.
Yes.
Frequency of appeals that comes to your commission.
On a daily
what does
basis.
It look like?
On a daily basis.
Numbers.
The numbers, I would say on a weekly basis, we should be having about 8 to 10. Yes.
8 to 10.
8 to 10.
Or asking.
Which means that the applicants have gone through the process and have gone through the level of the head of department, the head of agency also refusing it, and they are still dissatisfied and have come to the commission.
Okay.
So it takes a while for the process to get to the commission. But when it gets there, we look at it with all independence. Yes.
Well, you mentioned that it's not a media law, but in your opinion, do you think that generally the media has used the RTI to enhance their work?
I think
from what you know.
They have used it, but they can do better. Yes.
Because
most of the time, I see journalists complain on Facebook that I applied for this under the RTI law and I have not been given the information, and yet they haven't showed up at the Right to Information Commission to complain. So I say they can do better.
So you expect that they come to the RTI Commission instead of
exploit the processes to its fullest. Then you can see whether the law is working or it's not working. Yeah, but don't leave it in the midway and then complain. Then you haven't helped. Let's use the processes.
It appears you have a lot of confidence in the law in terms of its implementation.
As far as the commission, the governing board of the commission, management and staff of the commission is concerned, we only have this law to function. All we have to do is what is within this law. Anything outside this law, we cannot do. So we are confident that as long as the law remains what it is, you should expect that our decisions will be in line with this law.
Okay.
We did not make the law. We've only been put in place to implement the law. Yeah, we cannot implement law that does not exist. So we are confident that once the law is intact and it has not changed, you should expect that this is what we will implement.
And it does not matter who you are,
it does not
who
matter
is involved.
No one is...
No respecter of persons.
We are not to take any pressures from anybody in carrying out our functions. And so far, we have done so diligently. We have made decisions against public institutions, against governmental agencies. So it is for the public to tell whether the commission has lived up to the expectations.
Mr. Yasapon Boateng, we're grateful. Thank you so much for being a part of the show tonight. And that's the Executive Secretary of the RTI Commission, my guest tonight. And hopefully we've answered most of your questions when it comes to the RTI. I am Emefa Apawu, and on behalf of the entire team, many thanks for your company. For our radio audience, we have A Walk with Jesus. Please stay. There's more when you log on to myjoyonline.com. Have a good evening.